Mike Brown, the former FEMA director.
Joining us here is the former FEMA director.
History, I think, was very unkind to you, my friend. Very unkind.
Mr. Brown, thanks for being with us.
This is Michael Brown Unplugged.
Hey, everybody. Welcome to this episode of Michael Brown Unplugged. So I want to talk about yesterday, the Supreme Court heard the case for the DACA program. Now, to give you a little bit of background, former President Obama's program that temporarily shielded young people who came to the United States illegally as minors from being deported should be struck down, according to the lawyers, because it's unconstitutional and it was never authorized by Congress. That's the position of the Trump administration. There are about 700,000 or more individuals that are eligible under the Deferred Action for Childhood Arrivals. That's where the acronym DACA comes from, Deferred Action for Childhood Arrivals. Now, these kids, these individuals, are a subset of about 4 million or so-called what you hear referred to as dreamers. A lot of these failed to apply for relief under DACA, so could conceivably qualify under the kind of amnesty that Democrats and some Republicans are pushing for in Congress. But a bunch of federal courts blocked the Trump administration from terminating DACA and ordered the U.S. Citizenship and Immigration Services, USCIS, to keep taking applications from DACA recipients. Now, this is little kind of inverse of what you think. But what the Trump administration did was the Trump administration said that what Obama did was illegal by stopping the enforcement of the deportation of these children, and that by now enforcing that deportation, they're actually doing what Congress ordered them to do. So they're actually, the whole fight over the Supreme Court is going to be, in essence, it's not really the issue, but I think it will turn out to be the main issue, is whether or not the Trump administration had the authority to go back and say the Obama administration's refusal to enforce the law was unconstitutional, and what we are doing by enforcing the law is constitutional. Now, here's what happened since then. A lot of federal courts blocked the Trump administration from terminating DACA, and actually ordered, these federal courts actually ordered U.S. Citizenship and Immigration Services to keep taking the applications from DACA recipients. So the president tweeted early yesterday, many of the people in DACA, no longer very young, are far from angels. Some are very tough, hardened criminals. Now, between you and me, I'm not really sure why he needed to tweet that. There's a case pending. The oral arguments are taking place. And quite frankly, the court's going to ignore what the president says. They're going to pay attention to what the Solicitor General, that's the lawyer that argues on behalf of the government, and what those who are trying to make the case for these dreamers, they're going to listen to those lawyers. But here's the deal. Even if DACA is struck down, I think it's unlikely that its recipients will ever have to leave the country. When the president announced that he would end DACA back in 2017, he actually expressed sympathy for DACA recipients and said that his cancellation of the program was an attempt to force Democratic lawmakers to make a deal to allow those younger people to actually stay. He repeated that prediction in the same tweet. He said this: President Obama said he had no legal right to sign the order, but would sign it anyway. Now, if the Supreme Court, he wrote, remedies with an overturn of that decision, he says a deal will be made with the Democrats for them to stay. Now, a little sidebar. That has caused Ann Coulter to say that she is done with Obama. Now, Ann Coulter represents the chattering class. Ann Coulter represents... I don't think that Ann Coulter walking away from Donald Trump really represents those Make America Great Again folks that you see at the rallies. I don't think they really care what Ann Coulter has to say. But by the president saying that he wants to make a deal with the Democrats for them to stay, that has caused at least the Ann Coulter wing of the Republican Party to walk away. So let's back up a minute. Republicans have long called DACA a brazen power grab. They say that it is a usurpation of Congress's constitutionally prescribed role in making immigration laws. Now, before Obama created DACA back in June of 2012, just with the stroke of a pen, he acknowledged that such a program would be unconstitutional. The Heritage Foundation has a great article that talks about his acknowledgement that it would be unconstitutional, but that he was going to do it anyway. Back in 2010, Obama said, "I am not king," in response to pressure to act. He says, "I can't do these things just by myself." Then in March of 2011, Obama said, quote, "With respect to the notion that I can just suspend deportations through executive order, that's just not the case." That was in March of 11. In May of 11, Obama said that he was unable to, quote, "just bypass Congress and change the law myself. That's not how a democracy works," close quote. But then, lo and behold, 13 months later, President Obama did it anyway. He unilaterally, by executive action, upended the law. Now, DACA prevented recipients from being deported and gave them employment authorization as well as access to government benefits, such as Social Security. Now, as he created the program, Obama said that DACA was, quote, "not amnesty. This is not immunity. This is not a path to citizenship." He continued, "It is not a permanent fix. This is a temporary stopgap measure that lets us focus our resources wisely while giving a degree of relief and hope to talented, driven, patriotic young people," close quote. Well, after the Trump administration announced that it planned to end the program, then Attorney General Jeff Sessions denounced DACA back in September of 2017. He said at the time that DACA contributed to a surge of unaccompanied minors on the southern border that yielded terrible humanitarian consequences, and that it denied jobs to hundreds of thousands of Americans by allowing those same jobs to go to illegal aliens. Now, I don't want to argue whether that's true or not, but if you want to make the case that those people who came here who are willing to work for lower wages, of course it took jobs from Americans if those Americans were willing to take those jobs. So on the court's docket for yesterday were 3 separate lawsuits that were consolidated and heard as one lawsuit during oral arguments. The cases are the Department of Homeland Security versus the Regents of the University of California, Trump versus the NAACP, and McAleenan, who was the acting Secretary of Homeland Security at the time, versus Vidal. Now, the conservative justices, and I hate using that term, but we might as well just call a spade here, the conservative justices that constitute a 5-4 majority on the Supreme Court actually seem kind of sympathetic to the administration's argument that this highly controversial DACA program that for 7 years has halted removal proceedings against hundreds of thousands of young people was illegitimate and unlawful. They seem to be taking the position that Obama took. Yeah, what I'm doing is unconstitutional. But the liberal justices actually seemed more interested in the finer points of the legal documents that were signed by government officials that purport to end the program and in what they called the, quote, reliance interests of those who have lived, worked, and otherwise benefited under DACA. Justice Sotomayor, for example, told the Solicitor General during oral arguments that DACA recipients were entitled to something more than the 6 months of advance notice of the program's discontinuation that was offered by the administration. She said bluntly, "This is not about the law. This is about our choice to destroy lives." And I want to focus on that for a moment, because I think this is what drives me crazy about talking about the liberal wing of the court versus the conservative wing of the court. I think instead we ought to be talking about the originalist wing of the court that says we want to read what the law says and we want to apply the law to the facts, versus what you might call the living constitution wing of the court, the liberal wing of the court, which is, I think, summed up precisely in what Justice Sotomayor said. This is not about the law. this is about our choice to destroy lives. No, actually it's not, Justice Sotomayor. It is about what did Congress pass, what authority did it give to the president, whether that was Obama to simply suspend it, or to the president or to President Trump to say, no, I can't just suspend it. I'm going to enforce what Congress said. The Solicitor General, in response to Justice Sotomayor, said that the administration acted appropriately. He says that the rescission of the program, taking the program back, which he called a temporary stopgap measure, was eminently reasonable and is not subject to judicial review. He said it simply ended a previous non-enforcement policy whereby DHS agreed to enforce the INA, the Immigration and Nationality Act, against hundreds of thousands of illegal aliens. He said this, and I think this quote's important, but the decision whether or not to enforce the law is committed to the agency's unreviewable discretion unless a statute restricts it. What's he saying? The decision about whether or not to enforce the law is dependent upon whether or not Congress gave the agency, in this case DHS, the ability to review the law and whether or not the statute restricts them from reviewing it and changing it and discretionarily, it's not really a word, but in its discretion, deciding whether or not to enforce it. Now, Ted Olson, who used to be the Solicitor General of the United States during the Bush administration for a while, actually represented some of the DACA recipients. He told the justices that the decision to end DACA, which affects the lives of hundreds of thousands of people, which has engendered reliance, which reverses not only a position of two administration, but reverses the Office of Legal Counsel, changes policy, then all we're saying is that there's a presumption of reviewability of that decision. What's Ted Olson arguing? He's making the case that, look, this policy, which has gone back and forth, and that has affected all of these lives, that there is this presumption that you can review the decision. I think he makes a good case that based on the reliance, based upon the decision to withhold DACA and then to enforce DACA, to bounce back and forth, I think that creates a reviewable decision. So what about some of the new justices? Justice Brett Kavanaugh asked Ted Olson if the administration has the authority to rescind DACA, and Ted Olson acknowledged that it did have that authority. You see, I think what Kavanaugh's doing is Kavanaugh is asking, okay, under the language of the statute, does the president have the authority to rescind DACA? And if that authority exists, then a president, through executive order, can rescind it or can enact it. Either way. Responding to Justices Ginsburg and Kagan, the Solicitor General said that a key problem with DACA is that there's no limiting principle involved in it. He said this, the theory on which DACA rests effectively allows the government to create a shadow Immigration and Naturalization Authority for any category of aliens that it chooses to make low-priority targets, a shadow second-tier Immigration and Naturalization Authority. And you need to locate something in the law that confers that kind of broad and unfettered discretion, and there is simply nothing there. So the case is going to boil down to whether or not the justices find that in the statutory language, is there the discretion for presidents to enforce or not enforce this law? And if the justices find that indeed that discretion is given to the executive branch, then presidents can rescind it, enforce it, not enforce it. That discretion becomes unreviewable. That discretion is, by the language of the statute, given to the president. I know it's confusing. I know it's very confusing because of the way that President Obama said it's unconstitutional. I don't have the authority, but I'm going to do this authority anyway, and I'm going to stop the deportations. And then President Trump comes along and says, well, you were right. You don't have the authority, so I'm going to take it back and I'm going to start enforcing the deportations. That, in essence, is what the case is about. Does the president have that authority, and did the Congress give that authority to the president? That's the key decision in the case. There are all of these other things about reliance and whether or not these DACA individuals have some sort of case because they relied upon it or not. We'll wait and see what the case says. But in the meantime, I wanted you to understand what the very crux of the case was. Does the executive branch have this discretion? And the case, whether it has discretion or not, is going to turn on how they interpret what the actual language of the statute is. I think Kavanaugh, Gorsuch, Thomas, I think even Justice Roberts, they're going to look at the case and say, okay, let's look at the plain language of the statute. And if the plain language of the statute gives that discretion to the executive branch, then the president can do whatever it wants to do. I think the other wing of the court, even if they find that discretion, they're going to try to find a way that says, yes, you have the discretion, but you can't exercise that discretion if people have relied upon previous administrations that have said no more deportations. That's the case in a nutshell. Questions? Email. Thanks for listening. I'll talk to you tomorrow.